Hello and welcome to Devil's Advocate. How effectively has the Indian system tackled the Italian marine crisis? That's the key issue I shall explore today with one of India's leading lawyers, the former lawyer of the Italian embassy, Harish Salve. Mr. Salve, let's start with the government's handling and later come to the Supreme Court. Given that from the very outset, the Italian government had contested and not accepted the jurisdiction of the Indian courts, and secondly, given that the Indian government's claim that the incident happened in Indian territorial waters turned out to be patently wrong, should India have taken this issue either to international tribunals or arbitration rather than try and force the Italians to accept a verdict under Indian law?
Well, it's a very important question you're raising, Karan, and I must tell you, on merits, what you're saying is on the merits of the case. I think the Italians had an excellent case. The incident happened in the contiguous waters, outside Indian territorial waters. The vessel in question was a Tamil Nadu coastal registered vessel, which had authority only to be within 12 miles of Tamil Nadu's coastal zone. The vessel was way out of line. The Italian vessel had marines deployed, and these marines were deployed under Italian law. In cooperation treaty promoted by the UN, to which we are parties, because we are a high piracy risk zone. In a situation like this, possibly the better course for resolving it would have been international arbitration.
In fact, the truth is that even the Supreme Court in its judgment of January the 18th, when they ruled that India could try the case, actually not just permitted but even encouraged the Italians to raise the question of jurisdiction at the special court. Doesn't that suggest that ultimately the Supreme Court left the issue of jurisdiction fairly wide open?
Totally, totally. For the reason that all that was required to be done in the first instance is that if and when the court was constituted and all this had not happened, the first thing I would have done is put two Italian witnesses who would have proved Italian law, who would have proved why the Marines were deployed, and that may have been the end of the case.
In fact, if you had then succeeded, the consequence would be that the special court would have ruled that India doesn't have jurisdiction.
Absolutely.
And jurisdiction would have either transferred to Italy or somewhere else.
Italy, and the rule then would have been, if we feel that the Marines acted out of line, like if there is a complaint against Indian soldiers patrolling somewhere, you lodge a complaint with the Indian Army. We would have lodged a complaint with the Italians, who would have prosecuted them under Italian law.
So what you're saying, and I'm just repeating this because it's so important, is that if the present problem that has occurred hadn't happened, and if the Italian Marines had returned as they had promised to do so, then the special court in all likelihood would have concluded that in fact jurisdiction is not with India, and the case would have then transferred to Italy, and an Italian court would have heard it. And in fact, anyway, there is a case in Italy.
Yes.
You're right. The second thing you're saying is that being the case, with hindsight, clearly it would have been better for India to have agreed at the outset to handle this either by arbitration or through some international tribunal, because we've effectively then just wasted a year and a half.
Absolutely. You're absolutely right. This is where we dither. Every time we dither, we are not willing to take a firm position. You always try and see which is the softer option, and this is where you end up in a mess.
Was it bad legal advice that misled the Indian government, or was it some mistaken form of nationalism that this has to be handled in an Indian court?
If you ask me, the reason was the third reason. The arrest began in Kerala. We had election. There was a by-election in Kerala, and I'm told, I don't know how accurate this is, that the government was pretty precariously poised. There were one plus. Now, if they'd lost this one, it would have squared off, government would have fallen. There was huge sentiment in Kerala, and that is why the union government just sort of towed the line, because they didn't want to rock the boat.
So domestic Kerala politics and the impact that would have both on the state government in Kerala and possibly the central government colored the manner in which the central government handled this issue.
I have no doubt about that.
Now, given that the central concern here is the concern of jurisdiction, did the central government proceed to make matters even more damaging and worse by failing to set up the special court? Because even today, 2 months have passed and the special court doesn't exist.
In fact, someday if a story is written on how the government has been handling the whole matter relating to our seas, it'll be a very sad story. We made a law, the Maritime Zones Act. It is clearly not properly drafted. There are internal there are circulars in public domain which we produced in court, which the government started denying in Supreme Court.
Denying its own documents?
Yeah, saying, well, this is somebody's personal opinion, etc. But there was serious exchange of correspondence, circulars, clarifications on how the economic zone law is to work. Now, secondly, if you make an economic zone law which is going to operate beyond your territorial jurisdiction, you must have a federal police. You don't have a federal police. You don't have a federal court. They would have had to establish a court by law.
Is this the reason why, in fact, are these the reasons why, in the plural, why that special court that the Supreme Court wanted set up on the 18th of January still hasn't been set up, and we're now on the 17th of March?
Oh, absolutely. They are in a bind. Let me just tell you a small detail. The charge sheet is quashed. Who will file a new charge sheet? A police who has the power to investigate.
But they don't know who that police is.
Not Kerala. Then who else?
So you're saying a second very important thing. You're saying, whilst the dispute over jurisdiction continued, and whilst the government prevaricated over setting up a special court, we reached a piquant situation because in the meantime the Supreme Court had quashed the case in Kerala.
That's right.
And that meant that there were no charges framed by a court that faced the Italian Marines.
They are with an FIR.
Just an FIR, nothing more.
And that too, it's Supreme Court used their 142 jurisdiction. The FIR itself is by the Kerala police who has no jurisdiction. So you're in a bit of a hole there.
In fact, you're worse than a hole, because now, as you're saying to me, they don't know who the police are that are going to file the new FIR and file the new case in the court. Absolutely. They haven't got the system to do it. They haven't got the laws to do it. So suddenly the Supreme Court had ordained that a special court be set up, but none of the mechanism or the system or any of the rest of the paraphernalia needed existed.
Absolutely. And they were obviously unprepared for all this.
In this situation, how understandable is the frustration of the Italians, who suddenly found that their Marines were being detained in India? The Supreme Court had quashed the case in Kerala against them. Fresh charges had to be filed, but the court in which they would be filed didn't exist. The police and the laws to do so didn't exist. The paraphernalia doesn't exist. And yet, the Marines continued to be detained.
And that is why, Karan, if you see the last line of the Supreme Court order which permitted them to travel, added a very important sentence. Government must explain why the court has not been set up. That was one of the things which weighed with the court. You are, after all, detaining two foreigners. They've been here for a while. If they want to go home and vote and they are undertaking to come back and you have not set up a court, we allow them to go.
In other words, the court was clearly indicating that their anger over the delay was projected directly at the government, and the Italians would be the beneficiary, and the court understood the frustration the Italians were feeling at being detained without a system there to try them.
Absolutely.
In fact,
Absolutely.
the Supreme Court Chief Justice on the 22nd of February said, and this is how the papers reported it, was obiter dicta. I want you to confirm that this is actually what was said. Why is the centre dragging its feet? If the court would have been set up, the trial in the case could have been over. Why is it late? It would have by now decided whether they are guilty or not.
Small correction. He says it would by now have decided the matter of jurisdiction.
And that would have determined whether India can try it or whether it goes back to Italy.
Because, you see, after all, the judges also realize here are the rights of two human beings who are being held by somebody who may not have any jurisdiction over them.
And therefore wrongly held.
Therefore wrongly held. And they are not they are not rogues or pirates. They are officers of a military force. You are holding them without a court, without a system.
And therefore without possibly the right to hold them.
That's right.
In which case, I come back to the question I began with. The frustration that the Italians felt when their Marines were being detained, but there's no prospect of the case going ahead because the court doesn't exist, the law doesn't exist, the paraphernalia doesn't exist. That frustration is pretty understandable.
Oh yes, and that is why there was a big rumpus in Italy. There was a political rumpus in Italy saying, our boys are sitting there without a court, without a law. What's going on?
And none of this was understood or appreciated in India.
Because this was all not come into the public domain.
One last question about the government's handling before I switch and talk about the Supreme Court. In February 2012, when this incident happened, the Italians offered joint investigation, presumably leading to some form of joint handling, and at the time, the Indian government turned down the offer. With hindsight, would it have been better to accept it?
I think it was a fair offer the Italians had made at that time. They said, look, if our boys have acted contrary to our protocol, because you can't judge them by Indian Army protocol, you'll judge them by the Italian Marine protocol. Complain to us, there are prosecutors, they are independent of the government. They will take custody of these two boys, they will conduct a full inquiry, and they will prosecute them. Now you have made these two boys heroes in Italy by detaining them illegally. Now everything gets tainted. If you had agreed to it in good time, as a gesture saying, fine, you prosecute them, things would have been different.
Now that very process in Italy has been impaired by the fact you made the two of them heroes.
Absolutely.
in other words, what we're saying is that the Indian government have, in many respects, badly handled this case.
I have no doubt about that. Right from day one, they have been playing, they have been rather being dictated to by sentiment rather than cold, hard diplomacy on which these decisions should be based.
Let's now come to the Supreme Court's handling. There is a view that the Supreme Court has been indulgent or unnecessarily lenient in permitting the Marines to go back home in February for a second time, just 6 weeks after they went back for Christmas in December.
Karan, if the Supreme Court was not indulgent to the government of India's lapse, they could have said simply this: Kerala has no jurisdiction, proceedings quashed. The Marines would have been on a plane that very night. Bye-bye India. The court leaned in favor of Indian public interest and said, however, we would like the issue of India's jurisdiction to be decided. We will not allow the Marines to go. So the Supreme Court first stretched out and kept the Marines back. It's the first time in my little limited experience of 3 decades plus that 2 people are in custody of the Supreme Court. Bail had to be granted by the Supreme Court. They were reporting to Chanakyapuri police station. They are not Delhiites, they are not here. The Supreme Court could have just said, Kerala has no jurisdiction, their arrest is illegal, quashed.
So in fact, if the Supreme Court has been indulgent and lenient, it's not to the Italians, it's to the Indian side.
Absolutely.
And in fact, there was a very good case for the Supreme Court simply quashing and dismissing the case altogether
in Kerala,
rather than setting up a special court to examine whether there's Indian jurisdiction.
Precisely. They could have told Government of India, do whatever you want. Kerala has no jurisdiction. End of story.
Now, on the specific question of the bail that was granted, or rather the permission that was granted to the Marines in February to go back, at that time, did the Indian central government oppose the Italian petition that the Marines should go back for voting?
Neither in December, when the case was pending in Kerala, nor this time did the government oppose. In fact, to the best of my recollection, they've filed some sort of an affidavit saying some undertaking, etc. has to be given, but there was no opposition. In fact, they were pretty red-faced in court because the court said, well, what have you done to our direction?
Is one explanation for the fact that neither in Kerala nor in the Supreme Court in Delhi did the central government oppose permission for the Marines to go back, the fact that in their heart, even if they didn't say it publicly, the lawyers for the government knew that the merits of the case were not in their favor?
That's hazarding a guess, but I don't think that guess would be off the mark.
And would that also be true of the Supreme Court? When the Supreme Court was asked a second time, can we go back and vote? Would the Supreme Court have said, yes, let them, because A, we've got question marks in our mind about whether jurisdiction lies in India. Number 2, a special court has to be set up, and even though we can't say it publicly, we know that the laws, the paraphernalia, and etc. aren't there, and there will be a long delay. And therefore, for all these reasons, we are going to give the benefit to the Italians, let them go back and vote.
It's articulated in the order. Let me tell you why. The Supreme Court order says, as I told you, they could have just squashed Kerala and let them go. End of story. They create a situation in which they thought the government of India, if it was serious about these boys, could act overnight. We have ordinances overnight, would act overnight. When I say overnight, I mean 2 days, 3 days, 5 days.
None of that happened.
Set up a court and then take over. Now you are almost 2 months from the judgment. The government is doing nothing. So the court feels, have we sort of kept these boys back? The government is not doing anything. They want to go back and vote. They're giving an undertaking. The government is not particularly opposing. Let them go.
My last question before I take a break. The leader of the opposition in the Rajya Sabha, on the floor of the Rajya Sabha, claimed that the Italian ambassador had lied to the court when he said that the Marines need to go back and vote. Mr. Jaitley claims that in fact Italian non-residents can vote by postal ballot. Now, as the lawyer of the Italian government at that time, did you verify the statement?
I checked the statement. I asked him. The Italian law is in Italian language. So I said, get me an expert's opinion on affidavit. He got that verified. I said, put it on affidavit. So he put it on affidavit, which said that there are 2 or 3 categories of people who are allowed to vote. Not everybody. Now, please appreciate.
And the Marines didn't fall into that category.
What was their status in India? Were they Indian prisoners? Were they being tried in India? Were they charged in India? Or were they deployed in India?
Hence the question
If they had been posted in India, of course, they would have had a right to vote.
But they weren't posted.
They were not posted. They
The
were not
nub of
deployed.
which is that the Italian ambassador didn't lie, and Mr. Jaitley, in his accusation made on the floor of the House, was wrong.
I think his accusation was inaccurate because of what I know, of what I was told by the Italians.
Inaccurate is a politer way of saying wrong. Let's take a break at that point. When I come back, I want to discuss with you the Italian ambassador Daniele Mancini and the issue of diplomatic immunity. That's in a moment's time. See you after this. Welcome back to Devil's Advocate with Harish. Salve. Mr. Salve, let's come to the issue of Daniele Mancini, the Italian ambassador, and diplomatic immunity. Under Article 32.3 of the Vienna Convention, when the ambassador petitioned the Supreme Court for his Marines to go home, he ipso facto submitted himself to the jurisdiction of the court and in the process waived his immunity. The key question is, was that a limited waiver of immunity or a comprehensive waiver of immunity?
I think the question of immunity is really something which wouldn't arise for the simple reason. Immunity is when you're being dragged into a legal system and you say, I'm beyond it. When you are moving a legal system, you're a petitioner in a court, you are seeking relief from a legal system. Where's the question of immunity? He went to the court saying, allow my 2 Marines to travel on my assurance to you. Where is the question of immunity there?
So if I understand you correctly, you're saying the clauses and articles of the Vienna Convention apply only if the Indian government is seeking to impose the Indian legal system over the Italian ambassador. But if the Italian ambassador himself goes to the court and himself petitions the court and himself asks the court if he can plea before them, then the question of immunity doesn't apply.
Obviously, one quick example which will bring the point. Suppose he lies in a pleading to the court and the court says you perjured. Can he say, I have immunity? I can petition you, but I can lie.
So the distinction that many diplomats, including Kanwal Sibal, the former foreign secretary in our sister program, The Last Word, make between Article 32.3 of the Vienna Convention and Article 32.4, which says that beyond jurisdiction, you need a second waiver of immunity before any order or judgment of the court can be executed. You say that distinction doesn't apply in this case at all.
No, it doesn't. When you're subjecting somebody to jurisdiction, it is at 2 stages. First, the hearing of the case, second, enforcement. Here he is the petitioner.
That also means that the Supreme Court's order to the Italian ambassador that he mustn't leave the country can be enforced by the Indian government, and if it did so, it would not be breaching the Vienna Convention.
Not at all. Strauss-Kahn was held back in New York, wasn't he?
But he didn't have diplomatic immunity. He was a member of the IMF, which I think is a separate
He had a
entity.
diplomatic passport.
But I don't think the head of the IMF has diplomatic immunity.
Well, yes.
But your point applies here. Regardless of the Strauss-Kahn example, in this instance, what you're saying is
He's the petitioner.
there would be no question because he's a petitioner.
And Supreme Court orders have to be carried out by all.
So the opinion of Kanwal Sibal that the order of the Supreme Court restraining the ambassador from leaving the country is unenforceable is a wrong opinion.
Completely wrong. It has to be enforced by the police.
Let me then come to my last question. On Monday, the Italian ambassador has to explain to the Supreme Court why his government has decided that the Marines won't return to India. Are there arguments that he can present that might encourage the court to accept the decision of the Italian government and secondly, not construe it as contempt of court?
If he does, I think whole of India is waiting with bated breath to hear them. I doubt, but let's see.
What about one thing? In part one, you indicated the reasons why the court understood the frustrations of the Italians, in particular the 2 Marines, who were being detained without really facing charges, without a court to try them, the government delaying setting up the court, and therefore they were being held there. One didn't even know what their status was. If the court could understand all of that in February, might that understanding not apply now?
It's settled law that even an injunction or a undertaking to a court which has no jurisdiction, if breached, you're in contempt.
So the real problem is that the Italian ambassador breached a solemn undertaking and he is in contempt of the court, and he find it very hard to explain, leave aside, satisfy the court why he breached a solemn undertaking.
Absolutely, absolutely.
Will the court take action against him?
They will. The question is what? We wait and see.
Whatever that action is, by your interpretation of the situation, it is enforceable. Enforcing it won't be a breach of Vienna.
Our constitution commands everybody will act in aid and in accordance with the directions of
Very
Supreme Court.
quickly, could then the Italian ambassador end up in jail?
Theoretically, yes.
But in practical likelihood?
Well, it depends how the Supreme Court wants to deal with him. But they can, if they want to, send him to jail.
There is room for the Supreme Court to be understanding.
There always is.
Mr. Salve, a pleasure talking to you.